Welcome everyone to the Law and Business session. My name is Quinn Curtis. I've been a professor here for going on 12 years. I teach in the Law and Business program, so I teach securities regulation, corporations. I've lately been teaching a seminar on environmental social issues in corporate governance, and a similar course over at the business school, the sort of law of corporate social responsibility. And I also teach a J-term class with a graduate of the law school who's also an entrepreneur on startup companies. All right, so I want to leave most of the time today for you to ask questions about the law and business program. But I wanted to start off by talking a little bit about what business lawyers do and why it's a really interesting part of the legal profession. And because I teach a class on startups, I thought I'd start talking about legal creativity and how it enables startups to get funding, and start with everyone's sort of favorite exposure to the startup industry, Shark Tank. So most of you have probably seen Shark Tank, where people come in and pitch some kind of wacky product, and the sharks watch, and then they say, I'll give you $100,000 for a third of the company, and the entrepreneur sits there and wonders if that's a good deal or they're getting ripped off, right? And this is not terribly realistic, but what is realistic, right, is that founders at a very early stage of their company need money to get the company off the ground, and they need investors to do that, and they've got to give away a percentage of the company to get that money in, right? And lawyers are going to come into this transaction for any number of reasons, right? It's a contract. It's a fairly complicated one. You need someone who's been there before to explain the rules. It's a securities offering, albeit an exempt one. You need someone to navigate that space. Lawyers in the VC space are often the matchmakers, right? I know someone who likes this kind of company, right? You also might need someone to negotiate hard, right? Is a third of the company for $100,000 a good deal? I can pound the table and maybe get you a better one, talk the investor down. Or maybe, right, because they've been there before, they can sharpen your pitch, right? Investors don't like to hear this. They like to hear this kind of thing. Can you tell that story? Can we help market your product to investors in a way that makes it more compelling for their needs? And lawyers play all these roles in startup companies. It's a very interesting practice area. But what all those roles have in common is that they're kind of a cost, right? You're bringing a lawyer in, and we're going to negotiate, and we're going to decide how to cut up this company so that we get the best deal for the founder that we can. And there's lawyers on the other side trying to do the same thing, right? And in law and economics, we call that kind of cost a transaction cost, a cost of trying to draw up a contract to strike some agreement. And transaction costs are just a part of life, right? And so the question becomes, you know, is this a transaction cost school where we are trying to teach you all to be the most effective transaction costs that you can? Which is, as I said, a very important part of our economy, but it's, you know, maybe not the most glamorous way to describe the legal job. But I submit that that's not all lawyers do, that the really neat part of business law is when we find ways to add value to transactions, right? And there's a contractual template that I think the Shark Tank people should probably be using, but of course it doesn't work on TV because it's a little complicated to explain. But it solves a lot of problems that would keep deals, like the Shark Tank deals, from happening. And it's a bit of legal creativity. It's called a SAFE, an acronym for Simple Agreement for Future Equity. And the idea as a SAFE is that, look, this problem comes up all the time. You've got a wacky idea. The shark says $100,000 for a third of the company. But guess what? The founder is always way more optimistic about what the company is worth than the investor. They're going to be at cross purposes a lot of the time. But how are we going to get money into the company if we can't agree what the company is worth? If I'm going to buy a part of your company in order to fund your startup, we kind of agree what the whole thing is worth. But of course, an early stage company is a very hard thing to get an answer to that on. I could give you a loan as an investor. I don't have to agree with that your company's worth any particular amount to give you a loan, but of course, as an investor, that's icky. Loaning to startups? I want to get rich. If you get rich, that's the whole point. That's why I'm doing this kind of investing. So the SAFE says, what if we took some of the features of the loan and some of the features of the Shark Tank style equity investment, and we combine them in a way that lets us agree to disagree about what the company is worth today. And so a SAFE goes like this. I'll give you $100,000, and we won't even say for what. I'm just going to give you $100,000. And what we're going to say is a year from now, 18 months from now, at some point in the future, maybe a venture capitalist comes in. And that venture capitalist is going to buy a percentage of your company, Shark Tank style. But by then, you'll have a prototype. You'll have maybe a product to market. We'll have professional VCs involved who are much more sophisticated about how to do the valuation. We'll have way more information than we do today. So if that VC comes in, the SAFE says that $100,000 is going to act like a gift card for you to buy some of the VC stock at a discount. And we can give lots of features to that that would give you some of the upside because you took more risk than the VC did. And if the VC never shows up, well, if the company fails, it fails. That was always a possibility, Shark Tank or not, right? And so the idea behind a simple agreement for future equity is to say, hey, look, you never actually had to agree what the company's worth today in order to do what you need as a business matter. What you need is money, and we need to give some value to the investor. But we can settle the question of exactly how much of the company later when we have more information. It's a cool twist on a loan or a Shark Tank style equity investment that solves a real problem. A problem that in every episode of Shark Tank, someone says, I don't know, I don't think I want to take that deal. And we say, let's just take that problem off the table. It means because of this contractual innovation, companies are going to get funded that wouldn't otherwise get funded. Products are going to get built that otherwise wouldn't get built. And lawyers in designing this type of contractual innovation are adding value. We're making companies more valuable. We're creating innovation where innovation might not have happened, right? And across business law, you see this type of structuring deals to work around transaction costs that might have stopped those deals from happening. And that's a really cool contribution of business law because it's additive, right? It's increasing the size of the pie, not just arguing over how we're going to split it. But the trick is, in order for that to work, you have to understand what's motivating the clients, right? You have to understand what the entrepreneur is thinking, what their goals are, their understanding of the risk. You have to understand what the investor wants out of this transaction, how their fund works, how they raise money, what they promise the fund investors, what kind of returns they expect. And so you have to have a really solid understanding of the business side of the transaction in order to be an effective attorney in that kind of context. And that's what the Law and Business program is about. So the idea of the Law and Business program is that we're going to have a series of classes that kind of lean into the business deals of cases, right? Instead of abstracting away from the numbers and let's just focus on the legal rule, we're like, no, actually, there's a lot of interesting things going on when you try to understand why were they trying to do this merger? How did they get to this price? Why did they disagree about the price? What were the motivations of the parties? And why, if we're dealing with litigation, did things go sideways? Like, what was it about the interaction between the motivation of the parties and the contract that went wrong? And we do that in a couple of different ways. So one, for those who don't have a finance or accounting background, we have a standalone semester-long Introduction to Accounting and Finance class that's absolutely fantastic because in one semester, you will leave knowing more than a lot of practicing attorneys about accounting and finance. And just that bit of knowledge is hugely helpful. We hear that very consistently from our alums. We have law and business versions as our sort of core business classes, corporations, securities, bankruptcy, and a couple of others. So you can opt in to what's really a slightly more rigorous, more quantitative version of those classes that brings in the accounting and finance concepts. And then we have just a plethora of upper level classes, some of them taught by faculty here, derivatives regulation and the like, and many of them taught by adjuncts who are senior practitioners who spent their career working on those kinds of deals. Many of those are short courses that can be done in a couple weeks for a credit hour. And they're, again, fantastic because you're getting exposure to these areas of practice from people who understand them inside out. And you can, in a relatively short period of time, without a huge commitment in your credit hours in your schedule, just learn a ton about these various aspects of business law. And so together, for those of you who are interested in this, and I submit it really is a fantastic area of law, it's an amazing set of opportunities to really build some sophistication before you go out into the world. And the nice thing is that this is structured in a way that's extremely flexible from your point of view. If you want to take the law and business section of securities but not corporations, it's fine. Vice versa, also fine. If you want to take these upper division classes, you decide late in your 3L year, like, oh, actually, business law is for me, it's fine to pick it up then. We maintain a lot of flexibility in the program. This curriculum is here for you to take as you want, but there aren't a lot of strong requirements around it. It's just an opportunity for you to get exposure to important law and business concepts. So I will pause there, and I'm happy to answer any questions you have about the law and business classes and law and business program at UVA.